What unfolded inside a federal courtroom today is something even veteran legal observers are struggling to process. In a moment that stunned reporters, jurors, and court staff alike, members of Donald Trump's defense team were forcibly removed from court by federal marshals after a dramatic confrontation with the judge, an episode that may permanently alter the trajectory of the trial. According to multiple journalists who witnessed the scene, this was not a routine dispute over evidence or a heated objection gone too far. This was a complete breakdown of courtroom order, triggered by a single piece of evidence the defense insisted, under oath, did not exist. At the center of the explosion, an email. For weeks, Trump's attorneys had built their defense around credibility. Their argument was straightforward. Any document issues were accidental. Trump relied on legal advice, and prosecutors were stretching ambiguous facts into criminal intent. The defense had managed to poke holes in timelines, challenge witness certainty, and project confidence. Legal commentators were openly saying the strategy was working well enough to keep Trump in the game. Then came the morning that changed everything. Prosecutors informed the court they intended to introduce one final email, recently authenticated, but already part of discovery. Before the document was even shown, the defense erupted with objections. That alone raised eyebrows. When seasoned prosecutors say one more exhibit and the defense panics before seeing it, something is clearly wrong. Moments later, copies of the email were distributed to the judge, the jury, and the defense table at the same time. The email was dated August 2022, right in the heart of negotiations over sensitive materials. Reporters say that within seconds of reading it, Trump's lead attorney jumped to his feet and demanded an emergency sidebar. The judge agreed and called counsel to the bench. That's where the temperature skyrocketed. According to journalists seated close enough to hear parts of the exchange, the defense attorney immediately accused the government of fabricating evidence. The judge warned him to lower his voice. He did not. Instead, he demanded an immediate mistrial. The judge halted proceedings and ordered the jury out. Once the jury left and microphones were live, the courtroom descended into chaos. Speaking directly into the record, Trump's lead lawyer accused prosecutors of hiding evidence, altering documents, and committing fraud against the court. The judge asked him to clarify his claim. That's when he made the statement that detonated his own case. He told the court, unequivocally, that his team had reviewed every email from that time period and that the document just introduced had never been produced to the defense. The prosecutor rose calmly. She informed the judge that the email had been turned over months earlier, listed in the production index, and identified by number. Then she delivered the knockout punch. The defense had cited the same email thread in one of their own pre-trial filings, conveniently excluding the most damaging portion. She handed the judge a highlighted copy of the defense's own motion. Witnesses say the room went silent. The defense attorney didn't retreat. He doubled down. He accused the prosecution of altering the email after production. The judge asked him directly whether he was accusing federal prosecutors of fabricating evidence. His answer was immediate. Yes. At that moment, the trial crossed into uncharted territory. The judge warned him that he was in contempt and ordered him to sit down. He refused, declaring that he would not be silenced and that the court was complicit in corruption. The judge turned to the marshals. "Remove him." As officers approached, a second defense attorney stood up and began shouting that the court was violating Trump's constitutional rights. The judge didn't hesitate. Him too. Both lawyers were escorted out as one shouted accusations of a kangaroo court over his shoulder. The remaining defense attorney, a junior member of the team, sat frozen at the table, suddenly alone in one of the most consequential trials in the country. Legal experts say what happened next may be even more damaging than the spectacle itself. Attorneys have a duty of candor to the court. Making a factual claim that is provably false, and then refusing to correct it, is among the most serious violations possible. Accusing prosecutors of criminal conduct without evidence escalates the offense dramatically. Refusing a direct order from a judge seals the outcome. According to multiple ethics specialists, the judge had no discretion left. Removal was not optional, it was required. This incident didn't just derail a hearing. It may have obliterated Trump's defense strategy. Trials are about credibility. Jurors may forget specific testimony, but they don't forget behavior. Watching defense lawyers be physically removed for lying and defiance sends a message no closing argument can erase. Trump now faces an impossible dilemma. Proceed with an unprepared junior attorney against seasoned federal prosecutors, or attempt to bring in new counsel mid-trial, likely without a continuance. Either option carries catastrophic risk. Legal analysts say the damage is already done. This moment also fits a broader pattern. Time and again, lawyers who tie their professional fate to Trump's most aggressive strategies find themselves sanctioned, censured, disbarred, or worse. From Rudy Giuliani to Sidney Powell to Jenna Ellis to John Eastman, the trajectory is painfully consistent. Defending a client is not the same as abandoning ethical boundaries. Bar associations are now expected to review today's conduct. Contempt proceedings remain on the table. Criminal referrals are not out of the question. The attorneys removed today may soon need lawyers of their own. Meanwhile, the prosecution moves forward with a jury that has just witnessed something extraordinary. Defense attorneys choosing confrontation over correction, outrage over accountability. In the end, this wasn't just a meltdown. It was a collapse. When lawyers would rather be dragged out of court than confront evidence on the record, it speaks volumes, not just about the case, but about the strategy behind it. The next phase of this trial will unfold under the shadow of what jurors just saw. The legal fallout is only beginning, and for everyone watching, one thing is now undeniable. This trial has entered a completely new and unpredictable chapter.